Access to justice remains a fundamental human right and is important for the realization of the rule of law. However, accessing justice in Zimbabwe remains out of reach for many people. Although guaranteed by local, regional, and international law, there are barriers that prevent people from accessing justice.
You actually then realize that once accused, you actually are screaming to remain afloat in a system that's already judgmental on its own before it pronounces a judgment.
Because you know what you're doing, other than something that comes as an emergence. It should never be an emergence, because we're talking about the rights of the accused person. For example, in this case, it's a murder charge. Their liberty is on the line.
The death sentence is the ultimate form of punishing offenders in most countries, including Zimbabwe. Execution is irreversible punishment, and if the accused people are not properly represented, innocent people can be put to death.
Ndofunga ndakasungunga nokuti ini hana yangu yangagara ichitya nokuti ndaizwa kuti tinonzi murder nemanzwiro andaita ndaizwa kuti inini kunofira mujere.
Pamutongo wacho manje handina kugutsikana nawo because yanga ifanikwa kuita capable homicide, but mutongo wacho yauzoita murder ndingarohwa 18 years in prison.
The Law Society of Zimbabwe, with support from the European Union, has been running a pro-deal project to assist citizens facing capital punishment with legal representation, as well as capacitating legal practitioners as part of efforts to assist citizens' access to justice. The project, which has been running for some time, offers free legal assistance covering bail application, trial, and appeals for murder suspects throughout the country's prisons.
We as legal practitioners owe it to society to represent those that are facing serious offenses in the third schedule on pro-deal basis. And such candidates range from maybe serious frauds to murder, as it were. And it's been an experience I've had to assist in from the time I began practice. So it's annually, you might get a matter or two per year.
There was actually a time where I was treating this issue more like it's a sentence. You are serving a sentence. It's more like a punishment if you are allocated a pro-deal matter. But with this current funding, I think there's actually a bit of improvement.
In all murder cases, an accused person is supposed to have a representation. So I think that's one thing that is commendable.
Icala lami elimbisejini lapha licala lemurder. Kulicala lemurder ekwenzakaleni kwalo sisenzeka sise ekhaya khona leBhinga. Sibe singabantu abekade besetshwaleni benatha. Kulo mdlalo wawukhona khona lapho. So baba khona ungazwanani kwami lomunye wakho ngale lapho esasihlala khona. So sagcina sesingabantu abalwayo. So kuntambama, so kumnyama. So kulweni esakwenzayo khona phana kwaba ukuthi khona yena laye wayethola isikhali esenjengesingqa. Wayikhipha ingqamu lana engumuntu ofuna ukungwazi. So lami ngangingumuntu lami wayelengqamu. So kulweni esakwenzayo kwaphana sekhipha ingqamu lana wayezama ukungwaza ngayo, wayehlile ukungwaza ngayo. Wagcina seyiwisile kodwa mina lami senginjani sengikhiphe yami. So ngagcina mina sengigwazi. So kumgwazini kwami ngamgwaza wagcina esiba ngumuntu osesifa. Wafa khona lapho ngesikhathi sokufa. Egqwetheni khona lapho ngadingelwa yihulumende. Mina ngokwami ngangela gqwetha. So ngasenza ukuthi khona lapho sisifike enkundleni sisinikezwa amagqwetha khona lapho indabanye sasila. So ngikho lapho nganikezwa khona igqwetha nami lamelayo kuyona indaba.
Yangu yanga iri murder. Ndoya ndakasangana nawo 2 days. So ndakatanga kusvika zvichinzi takundikana. So ndakatanga kusvika ndakasvika zvichinzi ndakagomirirwa nemunhukadzi amataura vaya ndikazonzi vakundikana vasungudzwa zvakanaka ndikazonzi kuri kuuya zvakava musi wa19 ndikashaya vakandimirira musi wa20 musi wa19 musi wa18 19 musi wa20 musi wa19 ndisangana nemurume ndobva vanzi nguva yadi yapera inozoya mangwana ndobva tapesana nguva iyoyo ndobva tazosangana mangwana.
Most of these beneficiary inmates were facing murder charges and were staring either death or lengthy sentences, such as life imprisonment. However, thanks to the lawyers who were seconded by the Law Society of Zimbabwe as part of the European Union project of assisting in access to justice, their sentences were dropped and in some instances had charges reduced to culpable homicide.
nokuchiona kuti munhu ari muindustry anoziva kuti at least munhu ndofanira kumirira sei, so chivimbo changa chiripo chokuti ndaitoziva kuti ndiri ndega ndaikwanisa kuzvimirira, but iye semunhu anenge akatombomirira kune dzimwe nyaya aikwanisa kuzoita kundibatsirawo.
Mina ngendlela embona ngayo njengoba kula magqwetha amela vele abantu amagqwetha ngayo uhulumende khona lapho mnini lesikhalazo khona ngokuthi khona ihulumende ngayo ingakwanisa ukuthi amagqwetha lawana ekwanisa ukuthola isikhathi esingaba nje isikhathi esingaba libanga kungakayi kufikwa ngale enkundleni, ekwanisa ukuxoxa lo muntu lwana ezwisisane lo muntu lwana kuhle kuhle, ngoba nanzelela ukuthi esikhathini esiningi thina vele abantu abaningi iphovu vele eningi vele phandle umthetho kasiwazi ukuthi kuhamba njani, umthetho kumi njani asiwazi, ngoba iningi lethu vele phandle abanye abantu kasifundanga, ikakhulu emakhaya asifundanga, asizwisisi ngendaba zani zomthetho. So khona kuyana kuyadingeka ukuthi nxa kuyikuthi ihulumende ilegqwetha elinikeza umuntu angamela ngale enkundleni ukwenzela ukuthi ebekwazi la ngama-rights akafanele ukuthi ebewazi ukuthi yena umanga kufanele ukuthi igqwetha libuye lixoxe lo muntu lwana kube lesikhathi bexoxa bebonke bezwisisane la kutshela ngendlela okumi ngayo icala la bebe sebesiyakuya khona enkundleni sebeqedile.
Hayi limaonero angu ndakaona sekuti sepandiri ndakaona sekuti mashandiro avo akanaka nekuti ndainzwa nekubvunzana kwavaita nekumirirwa kwandaita ndaitoona kuti hazvotori nani kuti pomo ndiri ndega ndaikwanisa kutadza kutsanangura zvakakwana asi ndaiona iwo ukabva kupindurana kwavo ndanyatsoona kuti hazviri nani nekuti ndingoshoora munhu anogona kumirirawo.
Basically, mainly the inmates that are represented by pro-DO lawyers are those that appear before the High Court of Zimbabwe, and they would have committed serious offenses such as murder. Such inmates are supposed to be represented by the pro-DO lawyers, which are, I believe, are sponsored or come from the Law Society of Zimbabwe. However, there are some challenges that inmates face with regard to representation by pro-DO lawyers. Basically, most of the challenges are with regard to resources. The pro-DO lawyers are supposed to have prior arrangements to meet with the accused persons before the court dates, whereby he or she, that's the lawyer, is given the background or an insight into the case and the circumstances under which the case was committed, so that he or she can represent the accused person fully in terms of knowledge. Thus, they will be having the knowledge of how the case happened. However, most of these lawyers have challenges of traveling, for instance, to meet the accused persons, who in most cases will be incarcerated. Hence, it is not prudent for them to just meet at the court during the court date without much information.
Pro-DO services are ordinarily funded by the government, but due to financial constraints, the services were minimal and nearly non-existent. In the traditional pro-DO system, the lawyer is only called at trial, and this affects their work as they will not have enough time to understand the case or assist the client. This has resulted in some accused innocent people being condemned to prison life, yet all they needed to avoid prison was legal representation from a fully informed lawyer.
The opportunity is actually provided, but it's belatedly provided. You then tend to realize that most of the times that you get in touch with the client, it's at trial stage. And at times it could actually be in the very last minutes of preparation for a trial that's set days away from the time you were notified that such a client exists. So this is why I say the opportunity is actually presented, but I believe it's a belated opportunity, in that all it then that leaves you to do is just run through the motions, draft some document under impromptu circumstances without necessarily being given the chance to explore the matter the manner you would have if due notification had been given to you. So it is a privilege that's actually in existence for those that are facing serious offenses, but however, I believe the right has just been given with one hand and taken away with the other, in that you actually don't get an opportunity to deal with all the issues involved in the matter from the time the person was actually arrested. You are not even afforded the opportunity to question certain pieces of evidence and even see them prior trial.
In most cases, as I've witnessed, some of these lawyers meet the accused persons hours, possibly on the same day the accused person will be appearing in court due to resource challenges. Thus the lawyer would have failed possibly to secure resources to travel to prison. In our case, Kam is some 33 kilometers away from town. Hence, resources might be a challenge. Hence, these lawyers may need capacitation. Secondly, we also as prison try to assist by arranging possibly a day or so before the court date by taking the inmate to court so that they can meet there and discuss. However, the court conditions, the cell conditions where the inmate will be locked up, they are awaiting a discussion with the lawyer, are not favorable or conducive for discussing. Hence, the most ideal situation would be for the lawyer, as I previously indicated, to visit the prison institution whereby we offer them some conducive areas for them to sit and discuss.
I'll give you a vivid example of the last matter I handled under the same framework, where even the court itself, even the prosecutor himself saw the weapon that was used to commit the offense in trial. We had to actually adjourn trial to allow the officer who was bringing the exhibit from another town and proceed, yes. So you can imagine then how limited my involvement as defense counsel was. If I was meeting a weapon for the very first time in settings in the middle of a trial, what more the rest of the other evidence, the intricate statements that were served on me under 48 hours. This particular matter was actually made known to us on a Thursday, late afternoon, around 3 p.m. Yet it was set down for the following Tuesday, meaning we only wrote a letter requesting to have consultation with our client on the Friday, which letter was received on Friday by the registrar, communicated to prisons that late afternoon Friday, and the client was made available Monday and before Tuesday trial. And this is when we actually had a chance to go through the state papers with the client, hear their side of the story. And mind you, there is two things to consultation. It's not just asking what someone's saying to what the state is alleging, but it's also making them trust you. You need them to unwind themselves and believe they actually can feed you with enough information, open up, understand what it is that they are also facing. They actually also are being denied a chance to look at the evidence that they are faced with in a relaxed environment. It's now all rushed, because on that same Monday I needed to draw up a defense outline that needed to be filed first thing in the morning on Tuesday when we're sitting in court at 10 a.m. So I can just use that example to show you the restricted privilege.
In my case, unique, something that was unique that caught my attention was when I visited the accused person. He didn't even trust me because I was new to him. So in the first 3 minutes, I had to build that trust with him because to him, remember, this is the person who was on remand for almost 1 year, 6 months. So he didn't know now that, in other words, I was on his side. To him, it was another person who had come to interrogate him. So now, really, the accused person, the program must start with the accused person. He must be told in advance that, no, the state is trying to secure representation for you. So this might be maybe a diversion, but I've seen maybe in other jurisdictions whereby the accused person is actually told that if you can't afford a lawyer, the state will give you representation. So I would say now, this accused person must be told that because you have failed to secure legal representation, the state will now make efforts to give you representation. To the extent that when I now go to see this accused person, he now knows that, okay, this is the person that has been secured on my behalf by the state. So in my case, the only way I could gain the trust of this accused person was I now told him that I've been assigned by a judge to represent him. All of a sudden, he now gained the trust in me that, okay, you're coming from the judge. You're not coming from the prosecutor, you're not coming from the police. So now I think the program must capture all that there must be synergy between the accused person and the lawyer. The system must accommodate the accused person. The system must accommodate the lawyer so that the lawyer knows well in advance that, okay, I've got a pro deal that's coming up. I have to go see the client, so that you create that relationship between yourself and the accused. And not only yourself and the accused, but also the state. Remember, the state is also involved because that's the one that's prosecuting the accused person. So the state must also know that this particular legal practitioner will represent, other than for us to meet in court.
While the Law Society of Zimbabwe has been instrumental in alleviating the plight of accused people facing serious offenses such as murder, the organization also partnered the European Union in a project aimed at training legal practitioners on how to represent citizens in electoral issues. In the 2018 elections, various electoral issues were brought to the courts by different political participants. Gift Konjana participated in the 2018 harmonized elections as an aspiring member of parliament for Chegutu West constituency. He, however, approached the courts with the assistance of legal practitioners over an alleged anomaly by the Zimbabwe Electoral Commission.
I was shocked that the Zimbabwe Election Commission actually had to proceed to announce the election results without verification of the V11s, all the V11s from all the contesting parties. Yes, they had their own V11s, but we had our own V11s as well. So we're supposed to be given an opportunity to compare our V11s with their V11s. And so when that happened, in fact, before it happened, they'd already announced their election results. And so we had to go there and demand that we have to compare our V11s. And when we did, we then found out that they'd actually made mistakes. And so they even concurred with us that they really had made those mistakes. And so they made efforts to rectify the mistake, of which they had to refer us to the courts, because according to the new Electoral Act, which was adopted just before the 2018 elections, it was not possible for them to just change the results and announce the new results. They had also to approach the courts. But when they did approach the courts, they were told that they had to pay a deposit of 2,000 so that the case would be heard. And because they had no interest in the case, they then asked me to pay the cost. And so I did. That's when I approached the Zimbabwe Lawyers for Human Rights for a lawyer.
Electoral matters, from my experience from the Konjana case and the few other petitions that I've handled, you cannot work on any assumption. You cannot take chances. The lawyer has to go the extra mile to make sure that the client's rights and interests are protected to the utmost possible manner.
Eleanor Roosevelt once said justice cannot be for one side alone, but must be for both. There is need for all stakeholders from the state, legal practitioners and citizens to work together and avoid the imprisonment of innocent people, especially those facing serious offenses such as murder suspects, so that legal representation is available at all stages.